On August 12, 2026, Lloyd's List Intelligence confirms the scale of a crisis that began weeks earlier. Marine insurers face between $1.5 and $2 billion in claims from casualties in the Middle East Gulf. Tankers are burning, cargoes are stranded. Iran is conditioning the reopening of the Strait of Hormuz on concessions from Washington. The strait carries roughly 1/5 of the world's oil and 1/3 of all seaborne trade. When it closes, the cost lands somewhere, on owners, insurers, charterers, and eventually on every consumer who buys energy. The first wave of claims has already forced reinsurers to reserve capital and pull coverage for any vessel entering the zone without a war risk premium. The toll is not just physical. It includes hull losses, cargo claims, crew repatriations, and pollution liabilities that will take years to settle. Shipowners are already rerouting thousands of vessels around the Cape of Good Hope, adding days and millions in fuel. In normal times, these costs are buried in marine insurance contracts and flag state paperwork. The crisis forces them to the surface. But under those claims sits a question that no one in Washington or London wants to answer. When a ship explodes off the coast of Oman, whose law actually governs the vessel? Who is legally responsible for the hull, the cargo, the crew, the oil? Under international law, the flag state is the country whose laws apply, whose courts have jurisdiction, and whose inspectors sign the safety certificates. The answer is not in the Gulf. It is not in the boardrooms of the big insurance syndicates. It sits in a 3-story office building beside a shopping center in Dulles, Virginia. That office does not own the ships. It does not sail the routes. But it holds the legal, regulatory, and corporate authority over the Liberian flag of convenience, the flag covering roughly 17% of the world's oceangoing fleet, more than 300 million gross tons. When the Strait of Hormuz closes, that Virginia office becomes the most important maritime regulator on Earth, and almost nobody knows its name. To understand that office, you have to understand a system most people never see. The ship on the horizon flying the Liberian flag is not owned by Liberia. It was not built in Monrovia. It has never docked there. Yet, under international maritime law, Liberia is the flag state, the country responsible for safety inspections, crew welfare, pollution prevention, and accident investigations. This is not a rare loophole. It is the dominant structure of global shipping. More than 70% of the world's merchant fleet sails under a flag of convenience, a country that has no real connection to the vessel, but rents its sovereignty for a fee. Liberia is the largest. The Registry's origins go back to 1948, when the United States emerged from World War II needing a large merchant fleet for national defense, but unwilling to pay American wages, American taxes, and American safety rules. Edward Stettinius, a former U.S. Secretary of State, helped draft Liberia's maritime law. The idea was simple. Let American shipowners register their vessels in Liberia. The ships would still be controlled from New York, still carry American cargo, but fly a Liberian flag and avoid most U.S. regulation. The Cold War then turned this arrangement into a strategic asset. American shipping companies could carry military cargo to Europe and Asia under a neutral flag, reducing the risk of being targeted and lowering operating costs. By the 1960s, Liberia had surpassed the United Kingdom as the world's largest shipping registry, a status it has held almost continuously ever since. Panama and Honduras adopted similar models, but Liberia's close ties to American capital gave it an edge. To fly that flag, a shipowner must incorporate a Liberian corporation. The vessel is registered in the name of that shell company, with the Liberian government nominally as flag state. The Liberian government did not need a coast guard or a maritime court. It simply issued a law, collected a registration fee, and let private administrators handle the rest. For decades, the registry was managed by a series of private firms. Then, in 2000, after Liberia's civil war had nearly destroyed its government institutions, a private American company won the contract to run the entire registry. That company is LISCR, the Liberian International Ship and Corporate Registry. From an office in Dulles, Virginia, LISCR now administers the registration of more than 5,000 ocean-going vessels, totaling over 300 million gross tons, roughly 17% of the global fleet. It collects fees, issues statutory certificates, appoints surveyors, and even handles corporate registrations for thousands of shell companies. LISCR's contract has been renewed repeatedly, most recently in 2020, and it now includes not just ship registration, but also the creation of corporate entities. A shipowner can incorporate a Liberian company and register a vessel in a single afternoon, all through the same private portal. The registry's growth has been staggering. In 2000, when LISCR took over, the Liberian fleet stood at around 50 million gross tons. By 2025, it passed 300 million, a six-fold increase driven by bulk carriers, tankers, and container ships from Asia. No Liberian official has ever inspected most of these vessels. The country's entire maritime administration consists of a handful of employees in Monrovia, while LISCR employs hundreds in Virginia and around the world. For a shipowner, the appeal is not just lower taxes.
A Liberian flag means the vessel is not subject to American labor unions, European environmental regulations, or Asian cabotage laws. Crew can be hired from low-wage countries. Safety standards can be met through private classification societies rather than government inspectors. And when something goes wrong, the legal trail disappears into corporate layers that no single country can easily unravel. The Liberian government receives a cut, but the daily operations, the decisions, and the legal authority sit in Virginia, not in Monrovia. That contradiction is the blind spot. The world's largest shipping fleet is legally administered by a private company in an American office park, and its owners, by design, are almost invisible.
LISCR is not a government agency. It is a private business. Its revenue comes from registration fees, annual tonnage taxes, and corporate services sold to shipowners. Every additional ship that joins the flag adds another stream of income. That means the company has a direct financial incentive to keep the flag attractive. Low costs, minimal interference, and fast paperwork. Registration can happen in hours, not weeks. A shipowner in Piraeus or Singapore can email corporate documents to Virginia, pay by wire transfer, and receive a Liberian certificate of registry the same day. The company markets itself as efficient and modern, with offices in major shipping hubs and a 24/7 response line. But that efficiency serves a darker purpose. The registry is also a legal shield. Once a vessel is registered through LISCR, the true beneficial owner, the person or company that profits from the ship, is buried under layers of Liberian corporate entities. LISCR provides both the ship registration and the corporate registration, so it can create the vessel and the shell company that owns it in a single transaction.
The Liberian government gets a fee, but has almost no capacity to investigate ownership, enforce safety rules, or prosecute misconduct. The company's incentive is not to police its clients, it is to grow the fleet. That conflict of interest becomes visible when something goes wrong. When a Liberian-flagged ship is detained by port state inspectors, LISCR surveyors often negotiate with the authorities. When a ship is involved in an accident, LISCR is the agency that conducts the flag state investigation, an investigation into its own paying customer. This is not an oversight system. It is a customer service operation wearing the costume of a maritime regulator. The company's executives rarely appear in public. They are former maritime officials and shipping lawyers who understand exactly how the system works. Their job is to reassure shipowners that Liberia is safe, stable, and cheap. During the 1990s, when Liberia's civil war made Monrovia a dangerous place to do business, the registry survived because it was already run from the United States. That survival proved the model. The flag state could collapse, but the flag could keep flying.
LISCR inherited that model and perfected it. The contract with Liberia gives LISCR broad authority to set fees, appoint surveyors, issue certificates, and manage the registry as it sees fit. The exact terms are not published in full, but Liberia's annual budget documents acknowledge that maritime revenue is essential. The government receives a share, but it has no operational control. The result is a sovereign function, flag state administration, outsourced to a private company whose first loyalty is to its paying customers. That is not a flaw. It is the product. The turning point came quietly. In 2025, Liberia became the first ship registry in history to pass 300 million gross tons. The announcement was not made by the Liberian president. It was made by LISCR from its Virginia headquarters with a press release celebrating a new record. That milestone did not happen because Liberian owners suddenly bought more ships. It happened because the global shipping market had been reshaped by war, sanctions, and rerouting. After Houthi attacks closed the Red Sea to most traffic, thousands of ships were forced around the Cape of Good Hope, lengthening voyages and raising freight rates. Shipowners scrambled for flags that offered low costs and minimal questions. Liberia, through LISCR, offered both. But the real engine of that growth is the legal architecture LISCR controls. Under the Liberian maritime law, the flag state is responsible for enforcing international conventions: SOLAS for safety, MARPOL for pollution, STCW for crew training. In almost every other country, these duties are performed by a government maritime authority, with inspectors, port state control coordination, and courts.
In Liberia, those duties are outsourced entirely to LISCR. The company issues certificates of compliance, it appoints surveyors in ports around the world, it investigates casualties. It even lobbies at the International Maritime Organization on behalf of the flag. That means a private company, paid by shipowners, is both the registrar and the regulator. There is no separation between the entity that sells the flag and the entity that polices it. The result is a system that works on paper. Liberia consistently appears on the Paris MOU and Tokyo MOU whitelists, meaning its ships are detained less than the global average. But those whitelists measure paperwork compliance, not real safety outcomes. A ship can pass an annual survey without a single physical inspection if LISCR accepts documents from a classification society. The classification societies themselves are private companies hired by the shipowner. So the chain of accountability runs from the owner to the class society to the flag state administrator, all private, all paid by the same source. Consider what happens when a port state inspector in Rotterdam detains a Liberian-flagged bulker for safety deficiencies.
The owner calls LISCR. Within hours, a LISCR surveyor is on a plane. The surveyor negotiates with the port state, arranges for minor repairs, and signs off on a conditional release. The ship sails. No penalty is imposed, no public record is created. The owner pays LISCR for the service, and the flag state has done nothing. This is not a rare incident. It is the daily operation of the registry. When a disaster happens, the cracks appear. Courts in the United States and Europe have repeatedly struggled to pierce the corporate veil of Liberian-flagged vessels. Plaintiffs seeking damages for oil spills, crew injuries, or wrongful death often find that the registered owner is a Liberian shell company with no assets. The managers are in Greece or Singapore. The charterer is a different entity. The bank that financed the ship is shielded by mortgage law. And LISCR, which holds the legal registration and safety records, is just a service provider, not the owner, not the operator. It can point to the Liberian government, which has no resources to enforce anything. The Strait of Hormuz crisis exposed this in real time. When insurers began tallying claims in August 2026, they discovered that many of the vessels caught in the conflict flew the Liberian flag. The cargo owners could not sue the flag state. Liberia is a sovereign country. They could sue the shell companies, but those shells held nothing. The insurers paid out, then tried to recover from the owners, and found that the ownership trail ended in a filing cabinet in Monrovia, or more accurately, in a database in Virginia. The system did not fail. It worked exactly as it was designed to work, spreading risk into the ocean while concentrating legal immunity in a private office park. The growth is self-reinforcing. More tonnage means more revenue. More revenue funds better marketing, more surveyors, and more influence at the IMO, which attracts more tonnage. Liberia's flag is now flown by ships that have never called at a Liberian port, crewed by sailors who have never met a Liberian official, insured by underwriters who never see the ship, and owned by entities that exist only as lines in a database. That is the hidden system behind the headlines from Hormuz. The crisis did not create it. The crisis merely made it visible. Back at the Strait of Hormuz, the insurance adjusters are still counting. The sea is littered with wreckage from tankers that never made it through. Families in Manila, Mumbai, and Odessa wait for news of crew members who are on board ships that no longer answer radio calls. In London, reinsurers are pulling coverage for any vessel entering the Gulf without a war risk premium. And in Virginia, the phones keep ringing. Shipowners want to know if their vessels can still fly the Liberian flag after a casualty. The answer is usually yes. Because in this system, a ship can burn, sink, pollute, and kill, and the flag of convenience remains. The Liberian Registry is not designed to punish, it is designed to register. That is the quiet mystery at the heart of global trade. The goods on your shelves did not just cross an ocean, they crossed a legal fiction. A ship may be owned by a company that exists only as a name in a database, registered by a private firm in an American office park, and governed by a country that has never seen the vessel. The Strait of Hormuz crisis is not just a geopolitical standoff, it is a stress test for a system in which sovereignty itself is a product.
When the next choke point closes, and it will, the world will again discover that the ships feeding it are not owned by nations. They are owned by files. A widow in Manila cannot find the owner of the tanker that killed her husband. A Greek shipping magnate watches his vessel burning on AIS from a Piraeus office, knowing that his legal exposure is limited to the value of a Liberian shell company. An insurer in London pays a claim and then files a subrogation lawsuit against a corporate entity that has no bank account. The flag state cannot be sued. The registry is a private contractor. The individuals who made the decisions are protected by layers of corporate law. This is not an accident of globalization. It is its foundation. The post-war American strategists who created the Liberian Registry wanted a shadow fleet that could serve national interests without national responsibilities. They succeeded beyond their wildest dreams. The fleet now serves no one nation. It serves whoever can pay the fee. And the fee is collected in Virginia, not Monrovia. The tragedy at Hormuz will eventually fade from the news. The insurance claims will be settled. The tankers will be replaced.
But the system that allowed those tankers to exist without accountable owners will remain. It will wait for the next war, the next blockade, the next oil spill. The question that remains is not whether Virginia should regulate the world's largest fleet. The question is, if that office were to disappear tomorrow, would anyone be able to prove who actually owns the ships carrying the world?